Alrighty, first case to come before the court is State versus Wood, and Mr. Kudici, you're arguing solo, so you have 15 minutes.
Yes, Your Honor, thank you. May it please the court, I am Richard Kudici. I am court-appointed counsel for Dominique Wood. You know, I felt it important to come today represent for Dominique, because I think I know what you're going to say, or maybe what you're thinking. You know, Richard, it's not our job, it's the Court of Common Pleas job to do sentencing. Why are you coming at us? You know, the sentence not contrary to law, it's in the statutory range for a first-degree felony. The state's not even arguing, it's pretty obvious. You know, State v. Foster, State v. Markham. Your Honors, State v. Markham is exactly why I'm here today and why it's this court's job to take a look at this case. You know, Dominique did an awful thing. What I say, whatever, I don't need to minimize it. But the person, a first offender, no history, Ken Moore, 3.6 grad, freshman at App.No, worked, Ken Stewart's, Turkeyfoot Elementary, accepted full responsibility, very remorseful, a low-risk offender, reoffender, productive life, employment. Now, what does State v. Markham tell us? It removes the standard of abuse of discretion. I think. Does it? If it's not contrary to law. Now, in 37 years, Your Honor, I'm not sure if I can remember a sentence that was quote-unquote contrary to law. So if this court does have the power, the ability to modify this sentence if it finds clear and convincingly that the record does not support this sentence, and I believe very clearly that this record does not support a sentence. The court simply didn't use the basic principles of sentencing here, and the sentence is just disproportionate to the basis, the behavior, and the offense. Your Honors, the punishment did not fit the crime in this case. Now, this is not a horrific crime. I know it's a bad crime. Dominique was intoxicated. For some unknown reason, she crawls into bed with this 5-year-old friend of the family, or extended family that she is, pulls her panties down, has oral sex with her, puts her fingers on her vagina. Not good. This is a one-time situation. This is not a continued product of ongoing molestation. There's nothing in her past as a first offender. She then admits the matter. She cooperates. She's very remorseful. What if this is one of our extended family members? How would we review this? Because an isolated event does not determine a sentence. And in this instance, 8 years is extraordinary. Now, some may say, you're going to say, well, wait a minute, Richard, you know, she's charged with a life sentence offense, and here the prosecutor gave her a break, reduced it to a first-degree felony with typical normal sentencing ranges. But what was the first indictment? Life? Really? Life? Life is for murder. Life is for extraordinary rape situations. Life is not for this type of behavior. And this is a prime example of why mandatory sentencing should not ever be enforced or in our code. And in the United States of America, you all know mandatory sentencing is being scrutinized by Congress. So thank God the prosecutor has some sense enough to say, wait a minute, that's not the nature of this offense. But 8 years, you got a 3, 4, 5, 6, 7, 8, 9, 10, 11 range for an F1 here. In this instance, the 8 sentence is kind of in the upper mid-range. I suggest to you this behavior and this individual, Dominique Wood, mandates at the best a lower range of sentencing, 3, 4, maybe 5 years. The record does not support an upper level sentence in this case. Now, I understand how this court may think that we are not here to challenge the court below who was there, saw everything, heard everything. But that's not the law. You do have the ability. If the, you look at the basic precepts of sentencing here, you want to have a sentence that's sufficient, but not greater than necessary to do several things. Reflect the seriousness of the behavior, provide deterrence to future of such crimes of an individual, protect the public, and provide rehabilitation. Dominique, in this instance, is not someone that we need to worry about by not only the expert's testimony, but all the things. She led a productive life, went to college, she has no prior history, she has no offenses whatsoever. She was fully cooperative, extremely important. She admitted, she showed her ability to have compassion for this young victim. The importance of acceptance of responsibility in this matter is critical because she saved the state from expense, more importantly than from the victim coming in. And really critically important when you look at this. This is not the worst form of behavior. Now, I know you're saying to me as well, Richard, come on, look what Dominique did. And she needs to be punished for that. But I can't find in the record, because that's what we're looking at, serious harm to this young victim, thank God. But it's not demonstrated. She certainly is troubled.
How are you going to measure serious harm? This is a 5-year-old child who knew what happened, told her mother the next day, told people at the care center. You don't know this long-term impact of what that child's going to remember for the rest of her life, right? So how do you measure serious harm when you're only 2 years into a life sentence for this child?
I think it can be demonstrated in the record by a number of things. Opinion, by the nature of the behavior relative to the individual victim, and how an expert can opine statistically. And secondly, most importantly, which I can't find anywhere in the record, what's going on with this little girl? What kind of treatment, what kind of effect? I mean, I'm trying to imagine it through. It's hard to conceptualize even after all my years doing this, but you know, I'm not sure how the impact was demonstrated.
Well, didn't the mother of the victim testify?
I'm not aware of that, Your Honor, no. But the
mother of the victim said the child is now a sad, worried, untrusting child who's confused and hurt.
I'm sorry, I thought that was the ground. You are correct. Right, those are the terms of the description of this young girl. Now, does that equate to serious harm? And so, not to minimize it, we've all been doing this a long time, but let's get back to the situational offense that was committed here. There's a low risk of reoffending. That's from the expert, the only testimony that we have. My client possesses no future harm to the public, and that's what's in the record.
Well, Mr. Cucci, maybe if you were just talking about someone who engages in this type of activity, but what happened was she was extremely intoxicated, and there must be a risk that she will become extremely intoxicated in the future and make these same terrible, well, I won't even say make these choices, because when you're extremely intoxicated, could not the court be also, the trial court have been cognizant of her alcohol abuse and how that could cause harm to the public in the future?
I'm sure that concern is elevated. However, that's not what the record supports, Your Honor. The answer as to why Dominique did this is unbeknownst. Was it for...
Exactly, even to her.
Yeah, well, no, I'm interrupting you, I apologize. No, I think we do, well, at least from her explanation, she told the police she was just so drunk.
Quite
So
true.
that goes right to Judge Hensel's point, I think.
Okay, so now we're
Lying
gonna...
herself is saying, I don't remember doing it, but I was so drunk, that's what caused me to do it.
Absolutely, and now we're gonna extrapolate to the future for risk offending, and that's where Dr. Orlando comes into play. I mean, what does the prosecutor say? This was the best report he's ever seen in his career. And I think that's significant. I mean, the doctor said she's an honest reporter, a low to moderate risk for reoffending. She comes in elevated because of the behavior. But what's critical here? The opinion the record shows this is a situational offense. So we gotta get rid of the notion of protection of society beyond a realistic, in my opinion, low-end sentence. 8 years is too much under this situation. It's unplanned. The low risk demonstrated by occupational academic stability, no ingrained psychosexual disorders, no prior events of such behavior. These things are all critical when it comes to the notion of sentencing. Now, if you take a look at the basic principles of sentencing, Your Honor, it cannot be supported in the record for an 8-year upper mid-range sentence. The family never requested prison time. The record simply does not support the precepts of sentencing, protection. Punishment is quite adequate in a 3-4 year sentence in this type of behavior for this type of individual. Now what we find, and that's not demonstrated in the record, if you take a look at the disproportionate nature of this sentence and then ask yourself, well, when we see cases coming in here and everyone's getting 8 years no matter what, because that seems to be the formalized routine for sentencing when you got a situational event of this nature. And that's not right, because that's not what the felony sentencing factors are all about. You even take a look at the PSI. In the PSI, there are 10 elements of seriousness listed there, but in this instance, in Dominique's case, there's only one marked, and that was the issue of being family, extended family related. And that's significant as well. So the overriding principles of protection of society, deterrence, punishment, all of those things can be served more sufficiently and more fair and just, Your Honors, fair and just, by a lower end sentence rather than 8 years. In this instance, there's no need to incapacitate her by the record. There's no need to deter her from future behavior by the record. There's no need, it can be, I should say, rehabilitating to be in custody, detention for a period. But Dr. Orlando says she's amenable to treatment and that low risk opinion. That's what the record is we have here. These can all be accomplished in 3 or 4 years. So I can ask, what if it was our family? How would we perceive the individual? And I think that's where the lower court lost its way. It did not look at the individual, Dominique Woods, sufficiently. It didn't apply the precepts of sentencing, the notion of the important guidelines. There's no evidence to serious harm here. I know it's a bad thing. State v. McGowan out of our court, this court here, 8 years is simply too much, Your Honors. It's not supported by this record.
Counsel, the state indicates that, in their brief, that the prosecutor sentencing actually requested 11 years. What was the rationale placed in the record for that?
What was the what?
What was the rationale placed in the record for that, if you're talking?
Yeah, the buzzword is this is a horrific crime. And if it is, let me just say the last thing. It's not demonstrated in the record, and that's the critical proportion here. The government has the burden, the duty to demonstrate this in the record to provide. So if we just say, oral sex on a 5-year-old is horrific, boom.
But isn't oral sex on a 5-year-old 2907.02A1B? She got cited under A2. So the difference is we don't care about the child's age now. So we've already lessened the degree of the felony by ignoring the fact that the child's only 5, right?
Yes, Your Honor, but if you put mandatory sentencing next to the reality of what we have here, then that's the reasoning behind not having a mandatory sentence in this case. Life is not indicated in this type of behavior, and the reason we can say that, there's nothing in the record that demonstrates extraordinary result for this young victim here. That's my
That's okay. I have to check where the
timer. Well, if there are no further questions there, then I thank you for your attention and to listen to me on behalf of Dominique.
We will take the matter under advisement and issue a written opinion that will be sent to you in the state of Ohio as well as the East Side Section.
Very good, thank you.
Have a good day.
Bye.